Great. Well, today we're going to be talking about Brexit and looking at some of the questions that we often get asked by US companies. So first, where are we now in the whole Brexit process?
Well, so we're 18 months into the 2-year notice period, essentially, for the UK to exit the EU, which happens on the 29th of March next year. And I think it's fair to say we're not where we would have hoped that we would be in the negotiations. So when the UK first served notice to leave the EU's lead negotiator, Michel Barnier, put forward a timetable where he expected the withdrawal agreement, the terms of the UK's leaving the EU, and a framework at least for the future trade agreement to be agreed at the negotiators level by October 2018. Clearly that hasn't happened, and we're not expecting that to happen this month. We're expecting a summit to be announced next month, November, and really both sides are hoping to have agreed a deal at a negotiators level, but there really are some key sticking points still, and it's likely that the timetable may slip further, possibly into December, but there is an awful lot that needs to be done once that agreement is reached at negotiating level, particularly on the UK side, to get the backing of the UK Parliament for any deal that's reached. And so if we don't have an agreement by the end of December, then we start to see more of a real prospect that there could be a no-deal Brexit. And really that is what businesses are starting to focus on now as being the real risk that they need to prepare for.
So in a no-deal scenario, what are the main things that are likely to cause difficulty?
Well, I suppose understandably a lot of the focus has been on the physical trade of goods across borders, and clearly things like customs duties and border checks would have the potential to have significant effects. But I think the message really is that it's not just about physical trade. So as you'll know, Emily, for pretty much all businesses these days, data is crucial. And the risk here is that if the UK leaves the EU without a deal, then on the 29th of March next year, it becomes what's known as a third country under EU law. And the UK doesn't currently benefit from an adequacy decision or a bespoke arrangement like the EU-US Privacy Shield. So the risk is that if, in that scenario, companies would need to fall back on contractual arrangements like EU model clauses or binding corporate rules to ensure that those data transfers of personal data are legitimised. So that's clearly a crucial issue. For product regulation, for example, that's another area that we're seeing more focus on, where it could lead to things that businesses might not have considered, like a change in the status of an organisation from an importer under EU law to a distributor, which imposes additional obligations and potential liabilities. And if that's a third-party organisation that you're talking about, they may not be particularly happy with taking on those additional responsibilities. And that's aside from things like potentially having to relabel products that are sold in the EU, or for more highly regulated products, potentially having to have them retested by an EU authorised body rather than a UK authorised body. So clearly a lot of issues there. There are a host of other issues on things like immigration or the protection of intellectual property, and we don't quite have time to go into those today, but at Osborne Clarke we've published a range of insights on those kinds of areas, and if that's something that's particularly relevant to a business, I think they really could do with looking into that in more depth at this stage.
And so what are the other sorts of things that companies should be doing now?
Well, I would say that the key really at this stage is, if you haven't already, to carry out a proper risk analysis for your sector and your particular industry, to identify not only the primary effects of Brexit, but also potential knock-on effects. So if it comes to the shipment of goods across borders, if there are delays, what would that mean? Could that potentially put you in breach of an agreement? Or, in relation to data protection, could that put you in breach of an agreement that might give the other party the option to terminate the arrangement? Or could Brexit trigger a material adverse change or a change in law clause? All these things need to be thought about. Could a no-deal scenario impact on the value of sterling, and how might your contract protect against extreme currency fluctuations? So I think all of this, having done that risk analysis, could mean that key contracts or standard contracts need to be amended. And again, it's best to do that at this stage. In some cases, that will include things like change in standard clauses that refer to EU in territory or in applicable law, and understanding whether that should or shouldn't include the UK post-Brexit. And in many cases, that will be obvious from the context, but not always. And I think the message here is that where there are difficult conversations to be had, the time to be having those conversations is now, while this is still a theoretical risk, rather than when there are real amounts at stake. And I think finally then, as we approach what we think is the end game in the negotiations, it's incumbent upon all of us to be keeping a closer eye on what's happening in those negotiations at key EU summits in October and potentially November. Those should give a good indication of whether we are in fact going to have a deal which would give a degree of respite for us, or in fact whether we might be looking more seriously at the prospect of a no-deal Brexit. And for all of that, I would say this, but at Osborne Clarke we produce a range of insights on Brexit, and we're helping businesses to understand the risks and prepare for Brexit. So please do check out those insights on osborneclarke.com, or speak to an Osborne Clarke contact to understand how we can help you prepare for Brexit.
Great, thank you very much for that update.